Hi, this is Richard Kelly. So, pardon my Yorkshire accent, I hope you can understand what I'm saying. So, Privileges Committee. So, I have thoroughly researched and studied this for a very long time, probably 10 years now. I've studied the case of Lord Hanningfield at Southwark Crown Court, which was brought by Jeremy Johnson KC, now Judge Jeremy Johnson KC. Patrick Gibbs KC was the prosecutor acting on behalf of the Crown Prosecution Service, who didn't know anything about parliamentary privileges. In that case, the judge was Alistair McReith. Other cases under this law as well, and I've also been studying and furthering the knowledge of the indemnity that we're covered by for petitioning the government as well. Now, I know this committee primarily and traditionally deals with the privileges of members of Parliament, notably the House of Commons. But there is only one privileges of Parliament. Privileges of Parliament is privileges of Parliament. It's either privileges of Parliament or it isn't privileges of Parliament. Now, I know that there is another committee that deals with public petitions, but privileges is privileges, okay? Now, in the Sir Thomas Erskine May Usage of Parliament book, which I have the first edition, and Parliament, this is the Parliament Staple Handbook, the go-to handbook for the usage of Parliament, which Parliament publishes on its website, but they don't care to publish all of it in its entirety. They're picking and choosing which parts they want the public to know about. In the first edition of this book by Thomas Erskine May, in the section on public petitions, which is when the people have the right to petition Parliament in matters of church, state and law by consent in writing or by other means, and we've got to take into account the 1661 Tumultuous Petitioning Act as well, which actually sets out what we're talking about when we're talking about public petitions. It's a good act to define what we're actually talking about when we're talking about public petitions. The Sir Thomas Erskine May book, if you look at pages 300 to 308, and this book is actually on Google, it's online, it's on Google Books, but I've actually got the actual hard copy of it here at home. It clearly and explicitly confirms within the public petitions section that public petitions are covered by parliamentary privileges. Confirms that quite clearly. Public petitions come under, fall within, and are covered by privileges of Parliament. That there is only one privileges of Parliament, right? And we get it. We have it. We're covered by it when we're engaging in these activities. Unless you commit fraud or lying, basically, unless you're not doing what you say that you're doing, okay, you forfeit it. And that's basically like the Lord Hanningfield case. He was accused of fraud, okay? There's lots I've got to say about the Lord Hanningfield case, but that's a separate matter. At the end of the day, they touched on matters of Parliament and they weren't allowed to hear the criminal case. There's so much more to say about that case in respect of Magna Carta and certain repeals and changes in law under the criminal law about 1967 and other things, but that's another issue, which I probably could take up with this committee, actually, to do with Queen Elizabeth and certain repeals which she could or could not make in regards to the opening of Parliament, which invokes the Speaker's petition and all ancient rights and privileges there are and have been invoked into use. Yet Elizabeth repealed some of them, and there's only 4 clauses left in Magna Carta. So that's another argument, but I'm not focusing on that now. I'm focusing on the fact that Sir Thomas Erskine May, the book that Parliament use and use as guidance and refer to, it clearly confirms unequivocally, without any doubt, with full confidence, that public petitions come under privileges of Parliament. And therefore, we clearly are using the 1688 Bill of Rights, right to petition clause, with its provisions that we cannot be prosecuted. It's illegal to be prosecuted. And you also get Article 9 as well, illegal prosecutions. It's matters that are being brought to the Parliament of church, state or law. And we also get the free speech clause as well. I think it might be Article 20. We also get the free speech in matters that are for the purposes of being put to Parliament, whether inside or outside of Parliament. And then you've got the 1689 Claim of Right Act, which says that you can't be imprisoned for these petitioning causes. But you are liable to civil action if you cause any damage to any members of the public in their own private properties and things like that. You are liable to civil actions, but you're not criminally liable. It isn't what the 1688 Bill of Rights is an insurance policy against criminal liability to the state for matters that you're bringing to Parliament. Now, all of those acts are completely thoroughly checked and in order. Now, this complaint we had people are opposing Sadiq Khan, the Mayor of London, against the ULEZ zone and the expansion of ULEZ. 5 London Borough Councils had a case against Sadiq Khan in the courts. But these cases were not just petitioned to the Mayor against the Mayor of London from London Borough Council jurisdiction. They were also petitioning Parliament. Now, all of the people acting under the Stop ULEZ campaign were making and holding materials, signs, banners, notices, words, representations, everything under the Town and Country Planning Act, which falls under the definition of an advertisement, including legal representations. And under the Town and Country Planning Act 2007, they fall under Class F materials, which are allowed to use an enactment of law. And in this case, they want in Parliament to stop the ULEZ zone expansion, and it gets the enactment of the 1688 Bill of Rights right to petition over those advertisements, over that material. And they were also opposing Sadiq Khan, the Mayor of London, for the election, and that is Class E materials in connection with referendums, London or parliamentary elections. And that's Class E materials. Note that in the Representation of the People Act 1948, in one of the sections, it might be section 47 or 48, there is an offence by the police called illegal canvassing by police officers. They're not allowed to touch with their hands, they're not allowed to move or interfere with Class E materials which are for the purposes of an election, which represent representations for or against in any way a candidate in election, which is the Mayor of London. The police can't touch it, so that they're not allowed to actually touch or move it. So how can they seize it as evidence? Now, these elections and the petitions are causes to Parliament, they're cases to Parliament, right? And we've got 3 of them here, okay? We've got Dave Fowler's petition, which was case number 652161 to Parliament. We've got John Wizamensky's petition, which had over 200,000 signatures to the Mayor of London and Parliament, and Tim Rowling's petition here. That's 3 petitions over the same matter, Stop ULEZ, which have to be amalgamated together. Tim Rowling even handed his petition in to Sue Hall, the Conservative councillor who was standing in the election for the Mayor of London as well. Sue Hall, she was going to stop the ULEZ zone herself if she got elected. That had 200,000 signatures. So there's actually 400,000 signatures here altogether, including the Parliament one, which is the same matter and cause, which is supposed to be amalgamated together, right? They're all to Parliament. Now, Gareth Johnson MP, subsequently following these petitions, he, and also because of all of the public remonstrations, the public remonstrations as it's worded in the 1661 Act, all of the representations made in public under Class E and F materials opposing the Mayor of London and the Stop ULEZ campaign, all of these advertisements, they are all classed under the Town and Country Planning Act as advertisements to the public in a casework, and the public are the clients. The public are the clients of Parliament when they're in a legal case, because they're the ones who sign the petitions that Parliament are running, right? The public are the clientele, right? And they're the subscribers of the petitions, because this is what these advertisements and representations are meant to be doing, collecting more evidence of public support and public concern for these cases, right? Now, Gareth Johnson MP, he actually did a motion in Parliament. So Gareth Johnson, he was an MP in Parliament, and he acted in a motion in Parliament resulting from the evidence of public concern, which was presented not only through at least 3 official petitions, but also through the public advertisements and representations, which were widely published, videoed, photographed, and many letters into Parliament from the Stop ULEZ protesters, from the remonstrations, right? So these activities, which were being advertised in public for matters of church, state or law, to get an action from Parliament, a case to Parliament, Parliament did act in a motion. Now, this motion wasn't successful because apparently the Labour Party did some speaking which went over time limits, right? And it didn't actually end up getting this put through, but it was actioned. There was action in the Parliament of England in respect of these cases, these causes, these 3 petitions, and the people who are promoting and advertising them all, right? So now some of these people, who are Nicholas Arlott, Kevin Stredder, Ali Young, Martin Whitehead and Lloyd Dunsford, these persons were arrested at Tooting and processed at Charing Cross Police Station for claimed harassment against the Mayor of London. Now, either the signs and notices either got are capable of harassment or they're not. It doesn't matter whereabouts you use them, because if they're capable of harassment, they are. It doesn't matter where you use them, right? Now, the thing is that this is where we're getting with this. This is case 01WW quadruple 1424, which you can see at the top of the screen here. 01WW quadruple 1424. The case of Nick Arlott, Kevin Stredder, Ali Young, Martin Whitehead, Lloyd Dunsford. It was at Westminster Magistrates Court on the 9th of August, which was last week. And there's a trial being set on the 27th of November 2024, right? Now, in the Criminal Procedure Rules, the Criminal Procedure Rules 2020 are different from the 2015 Criminal Procedure Rules, because the 2020 Criminal Procedure Rules include provision and clauses for legally privileged items, legally privileged information in respect of legal cases and clients. Stop ULEZ is a legal case to Parliament. Here are the cases. There are 3 published cases to Parliament. It had a motion in Parliament with Gareth Johnson. Normal crimes. If someone robs a bank, it's not in any way connected with a motion to Parliament. If someone headbutts someone, unless it's a headbutting someone in Parliament, which has happened before actually, it's not usually, if someone steals a loaf of bread, it's got nothing to do with Parliament, right? 99.9% of crimes don't have anything to do with Parliament and can't claim anything to do with Parliament or any other case, unless it's some sort of divorce case and there's a struggle with the wife over who owns what items and they get broken or whatever. But look, that's not Parliament. That's just different cases, civil and criminal cases. We're talking about an existing official published legal causes to Parliament which actually have had a motion or motions, right? So these matters are in connection with Parliament and have had motion in Parliament. The clients of these cases to Parliament are everyone signed to these petitions. And who was the case being advertised to collect more evidence of public concern? The clientele is the public, right? Under the Criminal Procedure Rules 2020, legally privileged items and information in respect to other cases. Under the overriding objectives of the Criminal Procedure Rules, we have the requirement to recognise the rights of the defendant, and that is not to be mixed up with a defence against the charge. Part of the defence against the charge, proving a defence against the charge, or any time limits or restrictions within the procedure rules about any defence or a plea resulting from a defence. The recognition of the right doesn't have to be proved to a court or a jury, and it isn't subject to restrictions because it can be recognised in any proceedings. Any proceedings. Sentencing, first hearing, trial. People can have medical rights recognised while they're on probation. It's not constrained by a defence and not to be construed. If you read the Criminal Damage Act, the recognition of a right, privilege or interest is not to be misconstrued as a defence against a criminal charge. This is why the objectives are overriding of all proceedings. It's a legal requirement for the defendant's rights to be recognised by all parties. Now, when you're petitioning Parliament for an action in Parliament, you've got a legal case to Parliament, and Parliament are a party. Parliament are the authority which you are petitioning, so they're a party. And when you are covered by rights by those cases, it's the legal obligation of all parties to act and recognise on the rights that you're using, right? And also, in the Criminal Procedure Rules overriding objective HIV, it's a requirement for the court, and this is separate to any defence against a criminal charge. This has got nothing to do with pleading guilty or not guilty, or submitting material within any restricted time limits or dates or any specific hearing, right? The overriding objectives recognition doesn't have to be proved like a defence. It has to be proved with evidence. It only has to be recognised into effect, right? The needs of other cases. The needs of other cases. That's another overriding objective. Now, they're petitioning Parliament and the Mayor of London in a case. The needs of other cases. The needs of these cases are, firstly, privileges of Parliament, as confirmed by Thomas Erskine May. The needs of these cases are that they have to represent their concerns to the public. They have to represent the case and campaign to the public, all members of the public and any members of the public, including members of the public who might live near or around Sadiq Khan's house. including anyone who's got any shops or premises or companies even at the end of the road from Sadiq Khan. The banners, the words, the signs, the notices being held up which say "Stop ULEZ" and vote Khan out, vote Sadiq Khan out, Class E and Class F materials, they are legally privileged items. They're being communicated to the clients of that case, to Parliament, who are the public in that area, who they're wanting to sign the petitions or donate to the cause or email their MPs or whatever. That's legally privileged items which display legally privileged information on them, right? And not only legally privileged items and legally privileged information as defined now in the new criminal procedure rules, but it's parliamentary privileged items and parliamentary privileged information on there, because they are promoting Stop ULEZ as a whole, whether it's any of these three petitions or any of the public to email their MPs or to donate to the campaign. And Gareth Johnson MP only did a motion in Parliament because of the evidence of public support, the evidence of public evidence of public concern for that matter of Stop ULEZ. So it is covered with parliamentary privileges. Now, I have complained to the duty solicitor, which they've got legal funding for, Sundeep Pankahara, who is at GP Gower's Solicitors on Old Marylebone Road, which is the A5 out of London. And I don't think that Sundeep Pankahara at HP Gower Solicitors, he's a criminal lawyer. He works in the local area. He's not been trained in political law. He's not really expert. He doesn't. I don't think he understands the difference properly between being legally obliged to declare and claim a political right when it's in effect and defending a criminal charge. I advised the Stop ULEZ campaigners, and we're all part of the same campaign. We're all on oath to the same campaign, right? I advised them on claiming the right in a mention hearing or in the first hearing, and Sundeep hasn't done it. He's talked them out of it, and Sundeep is actually breaking the criminal procedure rules. Sundeep Pankahara is violating the criminal procedure rules. There's a legal requirement for every party to have those rights recognised, and it's naturally not up to the defendants. The wording is all parties recognising the rights of the defendant. It doesn't actually say the wording that the defendants will recognise their own rights. It says all of the parties will recognise the defendant's rights. That is a group effort. That is a culminative effort. That is the prosecutor, the judge, the defendant's solicitor, the defendants, and any other persons or parties who may concern the needs of other cases. That is all the petitioners in these petition, because they've got a case, they have an existing case, which has been unlawfully injunctioned by this prosecution. And they're victims. In the Human Rights Act, 1998, you can play all this back in slow motion, section by section, and write it down. I am not wrong about anything in this statement. The Human Rights Act, 1998, section 6, acts of public authorities. Public authorities are the police, the courts, the prosecution, and the local council, but not Parliament. Parliament is separate, and matters that are in connection with Parliament are separate from the public authorities, like these petitions to Parliament, right? Now, the problem is that in the Human Rights Act, acts of public authorities, when you're claiming a right under Section 7 of the Human Rights Act, Section 1B says that you can rely on a right in any proceedings. you can rely on a right being claimed in absolutely any proceedings. That is because it is claimed and recognised through the overriding objectives, and it is not claimed and recognised or misconstrued to be part of a defence against a criminal charge. Evidence presented in a defence against a criminal charge, proved to a jury as part of a defence against a criminal charge. It is recognised by the court. You don't have to prove it to a jury as part of a defence. And it's not constrained by any of the regulations through the criminal procedure rules for time limit, whether it's laid or presented within a certain time or through a certain procedure. No rule in the criminal procedure rules 2020 has any prescribed requirement for which a right is recognised or has to be laid or claimed. None. There is no prescribed procedure whatsoever. Only if there's an incompatibility with a convention right, then there is a procedure, a prescribed procedure for non-compatibility with a convention right. But we have got compatibility. There is compatibility here because we're claiming parliamentary privilege, we've got legally privileged items, and it's recognised through the overriding objectives. We're using the enactment of the 1688 Bill of Rights. All the material is under the Town and Country Planning Act, classes E and F, which you use the enactment of the Claim of Right 1689, the 1688 Bill of Rights, right to petition, illegal prosecutions in matters put to Parliament, and all of the freedom of speech article, which I think might be 20 as well. There's absolutely no way on this planet, in this country, in Great Britain, how these defendants can be prosecuted criminally by the South London CPS unit or the Met Police, right? Nothing. They can't be prosecuted. They're covered by privileges of Parliament. We pay our taxes. We're covered by national insurance. Everyone's got a national insurance number, all registered voters and citizens. The right is actually privileges of Parliament. And that's confirmed by Sir Thomas Erskine May. Now, this is public petitions. There is one committee in Parliament called the Privileges Committee. There is one privilege of Parliament, right? It's impossible for it not to be of matters concerning the Privileges Committee in Parliament. The committee can claim or try to convince us that it only is there to serve members. It's not only there to serve members. It's between the Privileges Committee and the Petitions Committee. They are a party in the petitioning because they're the authority being petitioned, right? These 5 defendants are victims of an illegal prosecution, and they have a right for their privileges to be recognised outside of the criminal procedure rules requirements. There's no time limit restriction, method of application. It only has to be recognised by the court, right? And that can be in writing or with a mention hearing. And Sandeep Pankahara is violating the criminal procedure rules. So are the South London Prosecution Service Unit. Now, I can complain to the Legal Ombudsman, I can complain to the Solicitors Regulation Authority, and the CPS have solicitors working there who have to comply with the Solicitors Regulation Authority rules, which includes complying with the criminal procedure rules. When they use them, they have to obey them. When they're not doing, I can complain to the Met Police. I can complain to the courts through the court's complaint form, and I can complain to the Judicial Conduct Investigation Office. But no matter who I complain to, when we're claiming privileges of Parliament, and when we're covered by privileges of Parliament, which we are in this case, it is the responsibility of the Privileges Committee of Parliament. Who else would be responsible for privileges of Parliament, right? Now, it doesn't take much for the Privileges Committee to write a letter to Sundeep Pankahara at H.P. Gower's Solicitors on Old Marylebone in London and say, Mr. Pankahara, we have reason to believe or report that you got 5 defendants who were doing Stop ULEZ petitions, and there's been a claim to us that they're covered by parliamentary privileges, and they need to be represented. The court needs to have them recognised. Would you mind arranging a mention hearing for these rights to be recognised, please? You can send a letter to H.P. Gower's Solicitors. They've got funding for the case. They've been granted funding for it, and that funding can be used for a mention hearing. They don't have to go do the whole entire trial, right? It's not complicated. I'm not wrong about one single thing in this talk. I'm not wrong about it. It's all fully compatible in law. Every single act that I have mentioned is compatible with this model, from the Human Rights Act, Section 6 and 7, from the 1688 Bill of Rights, Claim of Right, the 1661 Tumultuous Petitioning Act, Public Act 13 by Charles I, has been repealed, but it was repealed by the Public Order Act in 1986. But the Tumultuous Petitioning Act helps us understand what we're talking about in respect of public petitions, in remonstrations in matters of church, state or law, and by consent, by written hand or otherwise. So the Tumultuous Act also confirms that we're dealing with legal proceedings. A case to Parliament calling for an action is a legal case in the framework of this nation. It's a case, it has clients, the clients are the public, and the material being used is legally privileged items and legally privileged information. The police aren't allowed to take evidence from elections because they're not allowed to tamper with the material. If there is a crime or law breaking in respect of an election, you don't use the Criminal Procedure Rules 2020 that the Crown Prosecution Service bring crimes with, or the police. If there is a crime to do with an election, you have to bring an election petition. An election petition in connection with the prevention of corrupt and illegal practices. The Corrupt and Illegal Practices Prevention Act. The prosecutions for elections are not the criminal procedure rules. It's not standard normal police activity, seizing evidence and prosecuting with the CPS through the criminal procedure rules. It's different. It's a completely different a trial mode. It's a different area of law, like civil law and criminal law. It's a peculiar and unique area of law for an election petition. The police can't just go and take election material like for normal offences. So that's an example of legally privileged items and legally privileged information on those items. It's a very good example. If not, vote Sadiq Khan out or Stop ULEZ. It's not just legally privileged information. Stop ULEZ is parliamentary privileged information. We've had a motion by Gareth Johnson. We've got all petitions published, collecting signatures. What else? What other evidence do you want? If the police want to prosecute, Nick Harlett or any of the other protesters for any crimes under the election petition rules to do with elections, then let them do it. But these, under the 2020 criminal procedure rules, you can't prosecute that material is not capable of harassment under these criminal procedure rules because it can't be seized. The police can't take election material or Parliament petition material as evidence. It's privileged. If you want to take any action against it, they have to do peculiar proceedings, whether under the election petition rules or through the Supreme Court jurisdiction if they want to raise it to Parliament jurisdiction. And then, the Claim of Right Act 1689 says that you're not criminally liable anyway. You're only liable to civil action. If Sadiq Khan wants to go to the Supreme Court and claim that they harmed his image or his reputation for damages, but you'll find that in the very, very early copyright laws and all the laws to do with anything that is issued to the public, given or produced or presented to the public at large or a section of the public, you have the right to copy, display or show it, particularly if it's in respect of any matters, representations to Parliament, or let me think of what the word is now. I'm just trying to think of what the word is. So basically, any address to the public or at a public meeting, which includes a meeting in public of the public. So when all these protesters are actually gathering together in public and addressing the public, it's literally just like out of William Penn, basically, out of the William Penn, William Mead case. And also you've got privileges of Parliament apply to any address in public which concerns Parliament, all the way back from at least the Copyright, Patents and Designs Act 1988, but also the Copyright Act 1911, which is around the time they did the Public Meeting Act 1908 as well. So you get privileges of Parliament for any addresses in public and any copying or reproducing of any information, representation and address to the public. All that's covered by parliamentary privileges and the right to copy the message and share it in public under public meetings and addresses. So even if the civil side of it, the civil law side of it from us of Parliament for addressing the public and speaking and making copies of that or distributing it or addressing it through any means is covered on the civil side of the law anyway. So there's absolutely no way on this planet that the Mayor of London and the Met Police can prosecute or charge these 5 persons for the Stop ULEZ public remonstration, because all the items they were using and information on those items and words they're speaking are completely covered. Now, I've been talking 38 minutes now. I don't like having to make long videos, but it's not really that long. I need some action. I require action from the Privileges Committee to issue a letter to all parties. It can be the same letter, including an address to all parties, which is the South London Crown Prosecution Service Unit. The Crown Prosecutor of that unit, Lionel Iden. Lionel Iden is the Chief Crown Prosecutor at the South London Crown Prosecution Service Unit. David Malone is the Deputy Chief Crown Prosecutor at the South London Crown Prosecution Service Unit. The solicitor acting on behalf of the defendants is Mr. Sundeep Pankahara at H.P. Gower Solicitors and Old Marylebone, London. And then we've got the Met Police Chief as well. So there's 3 parties there to start with, and then there's the court, Westminster Magistrates Court. Now, in the case of Lord Hanningfield, there was employed a solicitor, King's Counsel, by the name of Jeremy Johnson KC, who is now Jeremy Johnson, Judge Jeremy Johnson KC. Well done for him, has been promoted in life. I don't think it needs employment of a lawyer. It doesn't need the employment of the lawyer. I am volunteering because I am subscribed to these petitions. I am a party in the legal case which is being unlawfully injunctioned against in a illegal criminal charge. These 5 defendants are victims of an illegal act, and their right can be recognised in any proceedings. I would suggest that their right can be recognised through a complaint to the court as well. So you've got Westminster Magistrates Court. I think it was either the district judge, Judge Clark, or there were 3 magistrates in that courtroom on that date of the 9th of August. There was Mrs. Ease, there was Mr. Lewis, and another magistrate. The name I can't remember the name of the third magistrate. There was Lewis, Mr. Lewis, Mrs. Ease, Justice of the Peace, and the district judge was Clark. So there's Westminster Magistrates Court as well, which the address is easily available on the internet. So the Privileges Committee, as far as I'm concerned, the Privileges Committee are a party because Parliament is the party being petitioned, and the cause was actioned by Gareth Johnson MP. He motioned a Parliament action to try to stop ULEZ, resulting from the caseworks, the 3 petitions, and all of the public letters, advertisements, and promotions. These cases are done in connection with Parliament. There's absolutely no question or doubt about it. I mean, I don't know how many times I have to say it. So the Privileges Committee in Parliament, I'm ill at the moment, under stress, so I don't want the letter sending to me because I'm. This is what I'm doing. I'm doing the complaint to Parliament now. Then it's set down. It's recorded. I voiced it. I voiced intricate legislation clauses and basis, which is correct, and all it requires is the Privileges Committee of Parliament to write a very short letter. It won't take long. All it has to say in it is, addressed to the following parties: the South London Crown Prosecution Service Unit, Lionel Iden, the Chief Crown Prosecutor, to Mr. Sundeep Pankahara at HP Gower's Solicitors at Old Marylebone, and to the Met Police Chief Officer. And it just needs to say, there's a Privileges Committee of Parliament, and it just needs to say, we understand that there are 5 defendants currently being prosecuted in case 01WW quadruple 1424, who are Nicholas Arlett, Kevin Stredder, Ali Young, Martin Whitehead, and Lloyd Dunsford. And they are being prosecuted at Westminster Magistrates Court. And there is a hearing, a trial now being arranged. They had a hearing on the 9th of August. The rights was meant to be recognised in that trial, in the hearing, on the 9th of August. Their rights were meant to be recognised and represented by Mr. Pankahara, but he seemed to not represent them when there's a legal requirement for him to. And there's been a trial arranged on the 27th of November. We've had a complaint from a member of the public who is party to these petitions. You can list the petitions if you want, or at least case 652161 with Parliament, that the privileges are not being recognised when there's a legal requirement and the needs of other cases. There was a motion in Parliament by Gareth Johnson MP for Stop ULEZ. These matters are in connection with Parliament. So, it's the prompt is enough. Mr. Pankahara surely has the capability and capacity to mention these to the court. So does the Crown Prosecution Service unit. So does the Met Police. So, you know, it needs mention. That's the short conclusion. This matter is required mention under the Criminal Procedure Rules 2020 Overriding Objectives Part 1. D. All parties are required to recognise the rights of the defendant to the court. The cases to Parliament, Nicholas Arlott and his group were representing these petitions. Gareth Johnson MP has acted in Parliament, so it's Parliament casework, and it's to the clientele of the public. It's legally privileged items. They can't be used as evidence in court. So the Crown Prosecution Service cannot offer any evidence. There's no evidence that they can offer because they can't use the evidence in the trial. So, you know, I want a short letter, please, from the Privileges Committee in Parliament. They can brief the solicitor, the defendant's solicitor. They can brief the South London Crown Prosecution Service unit, and they can brief the court. It just needs a prompt, you know, from the Privileges Committee. It's not a lot to ask when I know that these people are covered under privileges of Parliament by evidence of the activities of Gareth Johnson MP in Parliament. So, I mean, that's it really.